Welcome all. My name is Dr.B.S. Patil. I am from V.M. Salgaonkar College of Law, Goa. I am going to deal with access to justice in the light of provisions for the poor, and my module is module number 6, and in this whole process I have framed a scheme of my presentation which include a bit of a reality check, where we are going to look into really there is a differential justice delivery for poor as compared with the other persons, the constitution, how it looks into access to justice for poor, and then we move on to 3 important legislations, that is access to justice in the light of civil procedure, then the criminal procedure, and lastly I am going to take up the role of advocates. So therefore I am going to look into the act, that is Advocates Act, which provides for a kind of access to justice through the advocates, and then the other one would be the bill which is supposed to be brought into force, that again concerning with advocates. So when we talk about procedural rights, they are very important for a person to exercise his right, as well as in case of violation of a right he can bring it to the notice of the authorities so that the violated right can be redressed. In Constituent Assembly, when Dr.B.R. Ambedkar was making a speech, he said that if I am asked which is the most important provision of the Indian Constitution without which the Constitution would not survive, I would point to none other than Article 32, which is the soul of the Indian Constitution. Here I am bringing it to your notice of the statement of Dr. Ambedkar solely with an object to highlight the importance of procedural rights. So therefore here what I am trying to mention is Dr. B.R. Ambedkar was trying to highlight the importance of procedural rights. The existence of procedural rights is ensurement of enforcement of rights. So therefore providing the justice and providing right to access to court becomes one of the major functionaries of our justice system. If you look at our Indian justice system, we follow a formal justice system which is based on common law system, where the doctrine of precedent plays a major role. The judiciary, it interprets the law, it implements the law, but at the same time while interpreting the law it also ensures the evolution of law, looking into the evolution of the society. So therefore wherever a judgment of a higher court is passed, it is going to bind on its own subsequent judges as well as its own primary judiciary. Now before we move on to further discussion, let us again speak about the importance of access to courts. It is highlighted in one of the maxim that ubi jus ibi remedium, which mentions that where there is a right there has to be a remedy, and if this remedy is denied for some people, maybe because of some kind of a disability which can be economic, social, or maybe any other kind of disability. So such hindrance in access to remedy should be considered as a system which needs further development. So therefore wherever economic disability leads to non-access to justice, or is it an excuse for not providing justice, there we need to work on this system where it can provide for it. So here we are going to consider the Indian legal system, that is justice system, whether it provides for justice to all, ignoring economic, social, other kinds of disabilities. So that is what is going to be our today's discussion. The objectives of this lecture. So when I complete the discussion with you, I hope that I would be trying to highlight some of the importance of the procedural rights, along with considering the concept of poor that is envisaged by Civil Procedure Code and other legislations, the Constitution in the light of access to justice for poor, and then our regular discussion on these three important legislation, that is Civil Procedure Code, Criminal Procedure Code, and the legislations concerning the advocates. Now coming to the justice system. The justice system in India is a system which is going to cater to the needs of variety of people and cater to the needs of variety of situations. So therefore, as the situations are innumerable kind, having a law for those innumerable types of situations is almost impossible. Human brain has a limitation. So as the legislatures, when they are making a law, the law would be based upon the imagination power of a human being, that is the legislatures. So when they are working on it, they cannot think of all the situations, all kinds of situations. So therefore, what the legislatures have done, that they have given a special power to the judiciary, that is inherent powers. These inherent powers are enjoyed by both civil as well as criminal courts, and these inherent powers are exercised to achieve justice. To highlight my point, let me take up a small example. Say a case of impersonation. So impersonation is a situation where a person presents himself as somebody else. Say for example, a fraudster, an habitual criminal, he appears before a housewife, he knocks the door and introduces himself to the housewife as, say, a person who deals with the gas, the cylinder company, that is, say for example, Hindustan Petroleum, and he convinces her that the cylinder has to be changed or some other and then as a result of that convincing, he dupes that housewife. It is a punishable offence and the punishment is quite grave. Take another situation, a student who is genuinely concerned about the future of his close friend who could not clear the exams. So now there is a supplementary paper. The student offers himself. He makes a proposal that he is going to write exam on behalf of his friend so that he can pass the exam and continue with his studies. It is a case of impersonation because he is sitting writing exam for somebody else. If both are arrested and brought before the court, punishing both of them with imprisonment will lead to injustice. Why I say that is because while doing justice, we also look into the status of the criminal. So whether he is an hardened criminal or whether he is an amateur, whether this criminal can be reformed, whether this criminal can get back to the society and lead a life which contributes to the society. I find in the second instance that student needs a second chance. Again, I find that in the first case, the hardened criminal does not deserve a second chance. So here we are going to make a differentiation. Proved guilty, convicted is the first case. In the second case, proved guilty but refused to be convicted, left on admonition. Now this is what the judiciary does, and this is the level of freedom, that is the discretionary power the judge enjoys, and this is known as inherent powers. Why I am mentioning this is because the same inherent power should be used when it comes to access to justice for poor. So whether all are equal in the eyes of the law? Yes, according to Article 14 they are all equal, but in reality are they really equal? So when it comes to say access to court, the court is resource based. Now resource based court means the court functions are very complex, the procedures are very complex, and this complex procedure can lead to a situation where you need the assistance of a professional. So, economic stability, that person, a person with economic status and strength will employ a highly professional lawyer with higher qualification and higher expertise. That person is going to present the case in a better way, and that better presentation can lead to a judgment in his favor. So, therefore, our system is resource based system where a person with a better resource can get a favorable judgment. This is what in reality happens. So, therefore, it is the duty of the state to nullify this differential economic status as a cause for a judgment. How to nullify it? How to bring a person who is affluent and a person who is a poor on a same status in the eyes of the law, in the eyes of the court. That is what we need to work on. Now, if you look at access to justice, there are different kinds of injustices that can happen. All this while during my presentation I mentioned about injustice due to economic distress or weakness, but there is another kind of a person who is suffering from a duration weakness. Now, duration weakness means a person who cannot sustain the delay in the proceedings. For example, a person with a old age, he will not go to court thinking that during his lifetime he may not get the justice. A married woman, now she wants to take a divorce and lead a different life altogether away from her husband who is continuously harassing her. She cannot imagine getting a divorce in a matter of few months and so that she can get back to her own life. Now, these are the people who cannot survive the delay in the proceedings. We need a legislation to address both these requirements. So, coming to economic weakness, we have two options. Economic weakness can be addressed by a legal aid, that is under Legal Services Authorities Act. Under Civil Procedure Code, it can be redressed by exempting them from paying court fees, and that is what I am going to discuss in today's discussion as to how far these court expenses are meted out. Then comes duration weakness and how to address that. That is done by speedy process. So, we need to increase the speed of justice, and whether that is been done, that is what we are going to look into. So, Constitution, I will just browse through it. This is about the preamble which provides for a justice which is social, political and as well as economic, and this instructions or the mandate is not only for the legislatures, it is also for the judiciary, and they have to ensure the justice, social, economic as well as political. So, remaining with the Constitution, Constitution provides for two types of access to court. One under Article 32, wherever there is a violation of fundamental rights, we can directly go to Supreme Court and seek for redressal. The second is the Article 226, where the fundamental rights or any other rights, if they are violated, they can directly approach their respective high courts. So, this is where the Constitution does its brief job as to access to courts. Coming to the speedy process as a justice for the poor. So, this speedy process becomes a very important tool for protection of rights in criminal proceedings. The right for speedy process becomes meaningful, or it gains much bigger, larger meaning when it comes to a situation where the liberty of a person is being deprived due to arrest, due to denial of bail. So, therefore, speedy process has been a right, constitutional right under United States of American Constitution. So, therefore, the difference between the USA and Indian legal system is in USA it is speedy process is a right, but in India it is being inserted into Indian Constitution through judicial interpretations. Even though status wise both are same, but there is been a recommendation by NCRWC which is trying to incorporate speedy trial as one of a fundamental right by bringing in a new article number 30A, but it is still in pipeline and hope that it will see the light of the day. Now, coming to the speedy process and our judicial observations. The person you are seeing on the slide is Justice P.N. Bhagwati. The justice, when he was writing a judgment for Kadra Pehadia versus State of Bihar, he was amused with the delay and the inhuman approach of the judiciary. In his own words, I want to quote, Justice Bhagwati said, "It is a crying shame upon our adjudicator system which keeps men in jail for years on end without a trial." He went on to criticize the judiciary, his own judiciary, and added, "No one shall be allowed to be confined in jail for more than a reasonable period of time. We fail to understand why our justice system has become so dehumanized that lawyers and judges do not feel a sense of revolt at caging people in jail for years without trial." These are the words of Justice Bhagwati, where he is expressing what we call it as a judicial regret for what is happening in our justice system. The next justice, the Justice Krishna Iyer, he speaks about a procedure called a slow motion syndrome. So, he says our justice system even in grave cases suffers from slow motion syndrome, which is lethal for fair trial. So, he is actually bringing in a correlation between slow motion syndrome leading to unfair trial. Now, that relationship is very important to note, that wherever there is a delay in the proceedings, there is injustice happening to the person. Husainara Khatun versus the State of Bihar. Now, here again the court said that if a person has spent as an under trial in a jail more than the maximum punishment that can be given if proved guilty, then he has right to be, there is a violation of his fundamental right under Article 21. So, therefore, Judicial Observations in Qatar Singh versus State of Punjab, the court came up with the conclusion that speedy trial is an essential part of fundamental right to life and liberty. So, from speedy trial, let us move on to legal aid. Khatri versus State of Bihar, they said that a court held that a state is constitutionally bound to provide legal aid, not only at the stage of trial, but also when they are first produced before the magistrate or remanded from time to time. So, legal aid is a process or a service which a person is entitled at the stage of arrest onwards, not only at the stage of trial. Now, let us have a cyclic understanding of importance of legal aid, how important a legal aid is. So, let us look at a situation where there is no legal aid. A person comes to a court who is suffering from a lack of finance. So, lack of finance leads to lack of representation, or at least poor representation. This lack or poor of representation leads to lack of arguments or poor arguments. This absence of arguments or absence of putting forth his own point of view effectively can lead to miscarriage of justice, because I will be speaking on this point at the later stage also. Justice can be done by the judge only if he is supported efficiently by the bar, the effective intelligent bar. So, judge alone cannot do justice in absence of support from the bar. So, therefore, lack of finance leads to lack of representation, lack of argument, and finally miscarriage of justice, and this leads to exploitation, and again the cycle continues. Exploitation further leads to lack of finance. So, this is the importance of legal aid for our purpose. So, let us move on to civil procedure now. Now, civil procedure and access to justice by poor. In the Civil Procedure Code, they have used the term indigent person for defining or for representing or naming the poor person. And who is an indigent person? So, there are two qualifications to call a person as an indigent. Number one, he has no means to pay, or a property who is valued less than 1000. So, these are the two qualifications, and these qualifications comes into picture at two different situations. No means to pay becomes a qualification to be an indigent person if the fees have been prescribed. If no fees is prescribed, then the indigent person the indigent person will be declared where the property is less than 1000 rupees. So, these are the two situations which leads to indigency under Civil Procedure Code. And the indigence of a person is recognized both at the original suit as well as at the appellate stage. So, Article 33 the Order 33 of CPC provides for indigence support in original suit. Order 44 provides for the support at the appellate stage. Now, let us look into what kind of support that they extend. The support that CPC extends for an indigent person is exemption from court fee. Only because a person is not able to pay court fee, he shall not be denied of justice. He can come before a court, prove that he is indigent, and then continue with the case without paying court fee. Now, does the court readily agrees? No, the answer for this is no. The moment a person makes an application to be declared as indigent, the court conducts its own inquiry into it, and after satisfaction only he would be declared as indigent. Further, the court takes a serious view of indigency. Why I call it as a serious view? Because the status, that is indigent status, can be reviewed at any stage of the proceedings, and in the review if they find that he has overcome that indigency due to some changed circumstances, then immediately the court will ask for him to pay the court fee, and status of indigency would be withdrawn. So, it is not a judgment, it is not an order which is suffering from res judicata. It can be reviewed at any stage at any time, and it can be reviewed at any number of times. So, what is the object of this 33? As I mentioned, that the poverty should not be the cause for refusal of justice. So, therefore, the court fee could be exempted if he is suffering from or if he is inefficient to make the payment of court fee. Now, coming to the consequential things. So, at the time of presentation of a case, he is declared as indigent. Now, we are at the end of the litigation. At the end, the court declares that indigent person as a successful litigant, he wins the case, then what happens? The consequences are quite surprising. The moment a person is declared as winner or who succeeds in the case, the benefit that he is drawing from the case, on that benefit the court creates its court fee as a first charge in the sense that the court will satisfy its fees first, the remaining amount would be given to the indigent person. So, this is what happens if he is successful. So, he will not be getting the full benefit of the litigation, he would be getting the benefits minus the court fee. What happens if he is unsuccessful? At the end of the litigation he loses the case, then the court would ask the state to take all the steps to recover the court fee from the remaining assets of the indigent person. Now, why do they do that? Why do they recover even if the client is unsuccessful? That is something which we need to think about and talk about. Is it because the court or the legislatures fear about unnecessary frivolous litigations only because he is exempted from paying court fee? If that is the case, then most of the poor people will harass the other part of the society by filing frivolous litigations. That may be the reason, or else what? That is left to our own thinking, as the legislatures did not clarify this situation. But as far as I am concerned, I feel court fee payment by an unsuccessful indigent litigant, the reason may be only this: to discourage unnecessary and frivolous litigations. So, what is the final effect of CPC on indigent person? As mentioned by a court in R.V. De versus Chief Secretary, Government of Kerala, the payment of court fee as a scheme, that is under Order 33 and 44, suggests is that the payment of court fee is merely deferred, it is not wiped off. So, similarly, the court said that the court fee, payment of court fee at the initial stage is exempted. It is not exempted altogether, but only at the initial stage it is exempted. So, from poor accessing justice, now let us move on to a person who cannot afford time, and for him the CPC is been amended in the year 2002, and they brought ADRS, Alternative Dispute Resolution Systems, as a means of access to justice. So, here the 2002 amendment inserted section 89, and this insertion led to additional proceedings before filing of a suit. Now, what is the additional procedure? It goes like this: a judge, before taking up a case, he looks into the nature of a dispute, and if he finds that there is an element of settlement in the dispute and which is acceptable for both the parties, the judge would formulate a probable settlement and send it to the parties, their advocates, for their comments. And after sending this probable settlement to the parties for their comments, if the possibility of settlement brightens up, he would refer it to mediation, negotiation, arbitration, or legal lok adalat, depending upon the party's choice. This process has been criticized by Justice Ravindran in one of his judgment. Before that, he had written an article also criticizing this process, and I find there is a sort of merit in the criticism, and that is, how can a judge draft a possible settlement without hearing the parties? So, the procedure which has been mentioned by the section 89 should be postponed to the negotiators after the referral of a dispute. Speedy and state. Now, if you look at this, whenever any person is aggrieved by the action of a state, the party have a right to file a case against the state, but before doing so they have to follow a certain procedure. The procedure is issuance of notice. Before filing a case, a suit against the state, they have to provide a notice of 2 months duration. Why the special procedure? Why 2 months is given to the state? The object behind this is again ADRS. The legislatures feel that the executive should be given an opportunity to settle the dispute outside the court before it gets into status of litigation. So, therefore, here the 2 months duration would be utilized by the public officer or the department to find out the actual violation of a right and try to compensate for the violation or try to reason out with the party aggrieved by the violation and try to settle it outside the court. So, then comes the next, again a speedy process to resolve a dispute, that is compromise decree. Now, here again ADRS is being encouraged by the court, where the suit is pending in the court and the parties negotiate outside the court, settle the dispute outside the court, or the part of the dispute is adjusted outside the court. Immediately such adjustment, such settlement would be converted into a compromise decree by the court. This is again a case of encouragement for speedy disposal of a case. So, therefore, what I draw from this process, this discussion is that access to justice by poor, by exempting court fee, provision is there in CPC. Access to justice by poor in the form of speedy justice is also present in CPC, and it is present in a sufficient manner. Now, moving on to criminal procedure code. This is a proceedings which concerned with deals with the criminal cases where offences or crimes are committed against the society. The impact that the criminal judicial justice system creates on an individual is far more than a civil proceedings. Why it is more? It is because it has got a double impact. One, impact on the accused. The moment a case is filed, a criminal complaint is filed, his personal liberty would be taken away, maybe through an arrest. Worse than that, it would impact his psychology. He would be a broken man, mentally as well as emotionally. But the second impact of the same system is on the family of the accused. The stability of the family would be sacrificed through arrest if he is a breadwinner of the family. Stability would be affected even if he is not a breadwinner of the family, because that may lead to stigmatization of the whole family. The society may refuse to interact with such family where a person has been accused of a crime. So, therefore, here speedy justice and a justice in real sense becomes very, very important. The impact which I mentioned on accused and the family of the accused, it is uniform to all, poor, rich, important, not so important. But when it comes to poor, the impact would be multifold. First, where the poor is a victim of a crime. The poor goes to a police station to file a complaint. The complaint may not be registered. That is the first hurdle that he has to cross. Even if a complaint gets registered, action may not be taken. Second hurdle that he has to cross. Even if action is taken, the other affluent party can get a bail with effective representation and then intimidate this complainant. That is the third situation. So, the impact of criminal justice system on poor is multifold, even if he is a victim of a crime. And look at the impact where the poor is accused of a crime. Now, here the impact is widely different from the other side. The impact would be like prison violence. So, as the prisons are overcrowded and there is no classification of prisoners, hardened, regular, amateur, first timer, all are put at one, and these first timers who are meek and humble, they get crushed in the prison violence. Homosexual abuse, as the prisoners are kept away from the opposite sex, the natural urge of prisoners would be satisfied through these homosexual abuses. And again, who are targeted in this? The meek and the one who cannot defend themselves. Health problems. Now, this is another thing where a person who is already suffering from diseases because of poverty and lack of nutrition, and these diseases gets contagious and spreads all over when they are cramped in a crowded situation. Mentally ill prisoners. Now, these are the prisoners, there is no record as to how many mentally ill prisoners are there in our prison, but these mentally ill prisoners are again they also lead to a kind of violation of human rights. Families of the prisoners, as I already mentioned, the impact on them is also can be felt. Now, setting in a criminal justice system into motion itself can be an access to justice. Allowing a poor to file a complaint, allowing a poor to insist upon investigation can be considered as a setting in motion of a process, access to justice. FIR copy. A copy of FIR, he is entitled as a complainant at no cost, and if FIR is not registered, then he has a right to approach a superintendent of police and complain about the no action by the police. Even if he cannot move the superintendent of police, he can file a private complaint with the magistrate, judicial magistrate, and through that he can ensure the enforcement, the setting in motion of a criminal justice system. Assistance of lawyer can be sought at all these stages. So, therefore, there is a provision in CRPC where poor can access justice by setting in criminal justice system into motion. So, in Sukhdas versus State of Arunachal Pradesh, the court said that the court interpreted section 304 of CRPC and held that a conviction of accused in a trial in which he was not provided with legal aid would be set aside, being violative of Article 21. So, any conviction without legal aid can be set aside. Further, coming to the second part of access to justice, that is provide empowerment of a poor man. How do we empower a common man? By getting hold of all the documents which police are having. Number 1, police report, first information report, statements recorded under 161 of CRPC, any other documents which are relevant. So, all these if they are available to the parties, then that would be an empowerment of the parties as well as access to justice. Coming to last discussion of my topic, that is role of advocates in access to justice. Beginning, I want to mention, as you are already an advocate and coming for an higher studies, you and me, we all are privileged class, because we have a monopoly over our profession. No other person can interfere with our profession. When we enjoy the monopoly, who has given us this? It is the society, it is the state. So, as a result of that, we are duty bound to provide them with the service to the society in the form of legal aid. So, in American justice system, the bar mentions that defending liberty and pursuing justice is the paramount function of advocates, to promote meaningful access to legal representation, and the American system of justice for all persons regardless of their economic social condition is considered to be the paramount duty of the advocates. Magna Carta mentions, to no one will we sell, to no one will we deny or delay right or justice. This is again a statement which goes well with the advocates. Legal service which advocates are expected to provide means providing assistance or legal service in the field of law to the needy person, and it is not a charity. Please remember, legal aid is not a charity, but it is a duty of the welfare state, and we being the beneficiaries of the state, the duty falls on us. Advocates Act 1961 provided for a section 6, which said every advocate shall practice, I am going to read out the complete section for the benefit of discussion. Every advocate shall in the practice of the profession of law bear in mind that any one genuinely in need of a lawyer is entitled to legal assistance even though he cannot pay for it fully or adequately, and that within the limits of an advocate's economic condition. Here both the duty as well as exception is been said in one breath. The duty is to provide legal assistance to the needy. The exception is within the economic condition, limits of the economic conditions of the advocate. But this exception has led to various interpretations, which has led to a situation that section 6 became mere letters of the law. So, to overcome this, the court has come up with, the legislatures have come up with a new law which provides for regulation and maintenance of standards in profession, protecting the interest of clients and promoting rule of law. So, these are the three objectives. So, to provide standards in the profession, they have established ombudsman. To protect the interest of the clients, they have established a legal services board, and to promote the rule of law, they have created the objects. So, the first three objects are concerned with our topic, our discussion, supporting the constitutional principle of the rule of law, protecting and promoting the public interest, and improving access to justice. So, here I want to highlight one thing. So, the difference between the earlier legislation and present legislation is that there are no exceptions when it comes to providing duty to the towards the needy persons. Here the advocate is duty bound to provide free legal aid, and the financial weaker section that is been defined under the bill. So, this is the major difference between the two, and here I bring end to my discussion on access to justice and the poor. Thank you very much.